All right, today's docket is a two-part courtroom roller coaster. First up, Trayon Martin, facing a third-degree felony for obstruction or retaliation. The state offers the bare minimum 2 years, and he's trying to argue the facts before even deciding whether to take the deal, which is a dangerous game in front of a no-nonsense judge. Then we jump to Rebecca Riddle, who's pleading guilty across multiple state jail theft cases with a long prior history. The state is already trying to stack sentences, and the judge refuses to speedrun sentencing without a pre-sentence report. And just when you think it's over, there's a tampering case getting bumped up with an enhancement notice. This one is all about choices, consequences, and judges refusing to be played.
Good morning, sir.
Good morning.
Are you Trayon Martin?
Yes, ma'am.
And Mr. Martin, in cause number 25 DCCR 0270, you're charged with the third-degree felony offense of obstruction or retaliation from January 29th of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And what is the offer that's been made?
2-year TDC judge.
And so the state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case set for trial, but I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial, or do you want to take that offer?
Can I ask one simple question?
Sure.
I'm just trying to ask, I watched the video, how the case started, and I was the one that was fed up with it,
So that's what a jury's for. If you don't think you're guilty of what they're said, that
I mean,
then
I can't assert you if I'm already retired.
I don't need to know that.
Here's what's happening in real time. Martin is basically trying to litigate the case during a plea hearing. The judge keeps redirecting him for a reason. This moment isn't about debating guilt. It's about deciding whether to accept the offer or force a trial. A third-degree felony in Texas carries 2 to 10 years, and the state's offering the minimum 2 years. That's a solid deal if the evidence is strong. But if Martin truly believes he was set up, the correct move is to reject and let a jury decide. What the judge will not allow is a halfway stance. I'm not guilty, but maybe I'll take the deal later. Courts hate that because it wastes docket time and encourages gamesmanship. Viewers, what would you do here? Take the minimum now or gamble on trial where the ceiling is 10 years?
That's what a jury's for. Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
So,
And just for the record, I've explained this to him. I've shown him several different videos. Some of them are more relevant than others, and he indicates some things that there may be other videos out there that I don't know about. They're not there as far as discovery. He's indicated he wanted to hire Marsha Norman, and I told him you can reject it. If you're not guilty, then don't plead guilty and reject it, and if you can still hire Marsha in the meantime.
Mr. Nichols, is there any other discovery that you anticipate?
I didn't see any in the file from Ms. Volpino. Anything else, Your Honor?
Okay.
I know she made the offer. I know that he had got a reduction on the same charge a year ago, so I don't see any reason the offer would change. And I did ask for probation this morning. I did not change Ms. Volpino's offer.
Okay. So, Mr. Martin, if you don't want to accept that offer and you want it to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
Yes, ma'am. I just want to ask, I've been trying to get a job and work to see if I can, just see if it'll help me out with my time as a trustee.
Okay, none of that matters right now, okay? Because here's what we're not gonna do. We're not gonna put your case on the trial docket so that you think you can get some time under your belt, and then you're gonna plead guilty later, because after today, I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time.
The judge's tone shifts here because she's spotting a classic stall tactic. Martin starts talking about jobs, trustee time, and basically buying time in custody, and the judge snaps it shut. She will not put this on the trial docket just so he can sit longer and then crawl back for the same deal. That's a key courtroom principle. Plea offers are not guaranteed forever, and judges can refuse to accept late deals if they think a defendant is manipulating the schedule. She's laying out a clean binary. Either you did it and you plead, or you didn't and you go to trial. There's no third lane called wait and see. This is also why she warns that after today, she won't accept this plea agreement. She's protecting the process and calling his bluff.
Either you did it or you didn't do it. And if you didn't do it, then you can sign that and we'll get a jury to decide. But I don't want you to think you're going to come back in here later and say, oh, I want to take that deal, because it's not going to happen.
Yeah.
All right?
Am I eligible for parole?
I don't know when you're eligible for parole. I don't know how much time you have.
I never had to do this. That's why I'm asking
I know, and that's why Mr. Parker's,
be able to bail.
nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not us. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
I've explained to him how much time, based on what he's told me he has, and how much time I think he'll have to do before he's eligible. But again, I told him I can't guarantee that. But if you're not guilty, then don't sign. You plead rejection.
So it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and
I'm gonna go ahead on the sign.
sign what?
I'm not guilty.
You can't say you're not guilty and then sign for time. It doesn't work that way. Because what happens,
Officer?
for obstruction, it's not assault on an officer.
Obstruction, retaliation.
It's obstruction or retaliation, which is different. And there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it,
I want to go to trial.
okay, sign that for me, rejecting that plea offer then.
Okay, where?
Look, sir, pay attention, sign that.
Okay, where the at?
Right there, just defendant right there.
Okay. I got a hospital building. I got evidence in the free world.
So real quick, hold on, before you go back. Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes,
All right, so I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh?
Can I pick one or y'all?
No, you're going to get whoever's next on our list. If you have whoever's next on the list.
You can hire whoever you want.
You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay?
Yes, ma'am.
All right. You can go.
Quick transition. And notice how different this second case feels. With Rebecca Riddle, we're not debating guilt. She's pleading guilty across multiple theft cases with prior convictions stretching back years. That history matters because state jail felonies are low level until you stack them with repeats, and suddenly the exposure grows. The judge makes sure she understands there's no agreement. She's pleading open, meaning sentencing is entirely in the judge's hands, and the state immediately flags a motion to accumulate, aka stacking the cases because the offense dates are different. So instead of one short sentence, Riddle could be looking at multiple back-to-back terms. The vibe here is less argument and more, how much time is this going to cost you? And the judge is setting that expectation early.
Back with the bailiff. All right, you're Rebecca Riddle? And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, in this case, which is 23 DCCR 0928, you're charged with a state jail felony offense of theft of property with previous convictions from November 21st of 2022. The indictment alleges you were previously convicted of theft September 11th, 2010, September 17th, 2010 in two different cases. And then again, October 26th of 2015. And then September 21st of 2021 in three cases on that date. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are all those prior offenses and convictions true?
Yes, ma'am.
And then finally, in cause number 24 DCCR 1925, you're also charged with the state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges those same prior convictions of theft. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In each of those 4 cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it's my understanding you have no agreement in your case, in any of these 4 cases, and so you're just pleading open to me. Is that correct?
Yes, ma'am.
I want to make sure you understand your cases are set for trial. To begin with jury selection next week, you have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to
Yes,
do?
ma'am.
Sorry to interrupt, Judge. The state has filed a motion to accumulate, and we will be asking the court to accumulate those cases to the extent the law allows.
Okay, because they're all different offense dates, correct? Or at least,
Some of them are, Judge.
I think they are, nope, they're all different offense dates.
So we will be moving or asking the court to accumulate those.
And have you gone over that with your client?
Yes, Your Honor, she's aware that the state's asking for the charges to be stacked.
I guess part of my issue with this is, let's say I do something that Ms. Riddle doesn't like, and then she has the ability to appeal, and I don't guess there's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here, but
And Judge, I've looked for the path of least resistance to resolve these cases. We are in the situation we're in because it's defendant.
no, I don't disagree. Well, we'll get where we get. All right, so you understand that I can give you anything from probation up to 24 months, up to 2 years on each of these cases,
Yes, ma'am.
and I can stack those sentences on top of each other. Do you understand that as well?
Yes, ma'am.
And you want to go forward with these pleas and get the sentencing on these done. Is that correct?
Yes, ma'am.
Okay.
In addition, Your Honor, my client has asked, and I know the response to the court given the prior answer, but I am required to ask that the court, she's asking the court waive pre-sentence investigation on these and proceed with sentencing. She also would like to be released for her, I believe it's daughter's
And
graduation.
on Saturday from West Group.
State's opposed to that, Judge.
No, that's not happening. No.
This is a big legal checkpoint. Rita wants the judge to waive the pre-sentence investigation and sentence her right now. Plus, she asked to get released for graduation. The judge says no to both, and that's not just stubbornness, it's procedure. APSI gives the court the full map: criminal history, risk assessment, prior failures, and whether there are more convictions the court hasn't seen yet. With someone who has a substantial amount of history, judges rely on PSY before deciding whether to run sentences together or stack them. Also, the judge reminds her she can give up to 24 months on each case and stack them, meaning the total exposure can quickly multiply. So, the denial of a waiver is the judge saying, I am not sentencing blind, and I'm not letting you shortcut accountability.
All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history, obviously there's a substantial amount of history, and so I want all of the information. So we will get a pre-sentence report done in all of the cases, and I'm not doing anything with the bond other than potentially raising it to make sure that we're where we need to be when we need to be. So, that being said, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each of those cases. Is there any evidence that Ms. Riddle is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, if I may, on the tampering, Judge, it's filed as a third degree, but I filed a repeat offender notice seeking to enhance it to a second degree, given the defendant's previous robbery conviction. So I just want to make sure that all of that's.
Why did you put the tampering on me when you put the death on me?
Look, we're not, this isn't a conversation.
Confused. I'm sorry, yes, ma'am.
It doesn't matter, and they didn't put anything on you.
I mean, that's what I'm saying.
Okay, listen.
I don't understand how is it tampering. I mean,
That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of a second degree felony, which is between 2 years and up to 20 years. Do you understand?
yes, ma'am.
Okay. And so I will number that case for trial for next week. All right? You can go back with the bailiff.
Thank you, Judge.
Thank you. I'll let y'all know as soon as docket's done what the trial order is.
Thank you, Your Honor.
Yes, sir.
Let's tie this up. In Trayon Martin's case, the judge walked him through a third-degree felony offer at the minimum 2 years. And when he tried to argue the facts and stall for time, she shut it down. She forced a clean decision. Reject the deal and go to trial or plead guilty now. And she made clear the offer won't sit on the shelf forever. Then, Rebecca Riddle pled guilty in multiple theft cases with a deep prior record. The state moved to stack sentences. The judge warned her about the real-time risk, refused to waive the PSI, and reset the cases for sentencing, so she can get the full background before deciding how those terms will run. Finally, the tampering case was flagged for enhancement to a second-degree range if proven, raising the stakes to 2 to 20 years. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.